Yes, I'd like to mention WPC 5966 for listing in the next week, Your Honor. There is some urgency in the matter, Your Honor.
What is the urgency?
Your Honor, the public servant is been on suspension for more than 1 year, Your Honor.
You want it next week?
Yes, Your Honor. Any date next week.
Yes. You have it on, write the date. 10th of 10th.
My lord, my item number is 8, my lord. I want to withdraw my petition, my lord.
Achha. You want liberty to file again?
Yes, my lord.
Mr. I.C. Decker, learned counsel appearing for the writ petitioner, seeks leave of this court to withdraw the writ petition with liberty to file afresh. Since the prayer is not opposed, the same stands allowed. Writ petition stands disposed of on withdrawal with liberty as prayed for.
May I please, Lordship, I'd like to mention for listing, Lordship.
Listing what?
Lordship,
What listing? You come
Lordship,
find out what
Lordship,
listing and
it's in
come
the
back. Huh?
WPC writ petition.
Listing is done by registry. We don't do the listing. Go to the register and request it. Yes, next matter.
I beg to mention for item number 21, Your Lordship, kindly be taken in the next week.
On the request of learned counsel for the petitioner, this matter stands passed over for a week.
Lordship, I beg to mention item number 14 and 30.
Item number
14 and 30.
14 and 30, 30.
30.
You are for the petitioner.
Yes.
The same order, 14 and 30.
After the
May I please, Your Lordship? I beg to mention item.
Your name, please. Your name. Your name, please.
CDAS.
Huh?
MSC das.
MSc. You are not in the matter. Yes, MSc das. Naam to name.
I beg to mention item number 37, my lord.
Item number 37.
37.
What do you want?
With the
What do you-
consent of the other side, matter may be taken up on next week, my lord.
On the request of learned counsel for the writ petitioner made with the consent of the opposite party, admission hearing of this case stands adjourned for a week.
My lord, this is the application for withdrawal of writ petition, my lord. When we do on Monday, my lord. Deeply lordship.
Is this the company court now? Company judge? Why is this matter? Why item 41 has been listed here? Yes, Mr. Sekia. Which order has been violated?
My lord, at page 12, it starts from my lord, 11%, my lord, page 15, my lord.
Page 12.
My lord, order starts from page 15, my lord. And direction also you'll find at page 16 and 17.
His order is of 2007.
My lord,
It has been violated
yes, my lord,
and you have come now.
yes, my lord.
We'll
In the
dismiss
meantime,
it.
my lord, my lord, what happened, my lord? Contempt petition was filed, but the authority, my lord, they filed a review petition. Contempt petition was closed due to pendency of the review petition. And my lord, review petition was, though my lord, dismissed, again it was, my lord, appeal was filed before the honorable division bench. And while the division bench, my lord, dismissed allowed the writ appeal, my lord, along with the other connected cases, no observation was made in regards to the my lord, review petition. So my lord, recently my lord, review petition was also dismissed. In the open desk case.
Yes.
There is no my lord, observation.
So that's all right, but why the delay?
In the meantime, my lord, they file a writ petition also, my lord, for a fresh direction. This honorable court, my lord, observed that, my lord, last question, my lord, this honorable court, my lord, observed that, my lord, in the case, my lord, a contempt petition should have been filed. And that is why, my lord, the contempt petition has been filed.
All right, heard Mr. I.H. Saikal and counsel for the petitioner peruse the statements made in the writ petition. Alleging willful disobedience of the order dated 19/11/2007 passed by this court in WPC number 4759/2007. This contempt case is filed. Prima facie, the petition is barred by limitation. Full stop. However, Mr. Saika submits that due to a number of litigations arising out of the writ petition pending over several years, there was no scope for filing contempt case at an earlier date. Full stop. The said aspect of the matter will have to be examined after service of notice upon the respondents. Full stop. Be that as it may, in view of the averments made in the petition, issue notice returnable in 8 weeks. Petitioner to take steps for service of notice upon the respondents by registered post with AD.
Obliged. May I please, your Lordship? Lordship, non-applicable Honorable High Court order dated 23/2024, Lordship, page 12 to 15, Lordship. Operative for Lordship, page 15, para 4, Lordship.
Representation has not been disposed of.
Yes, Lordship.
You are Mr.
GG Gogoi.
Third, Mr. G.G. Gogoi, learned counsel for the petitioner, alleging willful disobedience of the directions contained in the order dated 23/2024, passed in WPC number 1600/2024. This contempt case has been filed. Peruse the statements made in the petition. Stop. Issue notice returnable in 8 weeks. Petitioner to take steps for service of notice upon the respondents by registered post with AD.
Makul.
Yes.
Item 3.
This is pertaining to the release of the retirement due. Petitioner retired on 31/1/22. Thereafter, he received some amount, my lord, but an amount of around 11 lakh is payable to him.
Right, I had Mr. S. Sharma and a counsel for the writ petitioner, peruse the amendments made in the writ petition. The petitioner's case is that he had retired from service under the Barpeta Road Municipal Board on attaining the age of superannuation with effect from 31/1/2022. Full stop. Notwithstanding the same, the complete retirement dues of the petitioner, such as gratuity, leave encashment, etc., have not been released to him till today. Stop. Aggrieved thereby, this writ petition has been filed seeking a writ of mandamus. Full stop. Issue notice returnable in 6 weeks. Mr. J.K. Goswami, learned government advocate Assam, appears and accepts notice for respond numbers 1 and 2.
1, 2, and 4.
1, 2, and 4. As such, service of notice upon the respond numbers 1, 2, and 4 is deemed to be complete. Extra copies of the writ petition be furnished to Mr. Goswami within 3 days from today. Petitioner to take steps for service of notice upon the respond number 3 by registered post with AD. Full stop. It is made clear that pendency of the writ petition shall not constitute a bar for the authorities to redress the grievance of the petitioner in accordance with law. If so advised.
Dues are, my lord, CPF, gratuity, leave encashment, and area salary.
CPF, gratuity,
Leave encashment and area
and
salary.
area survey, cited.
Item 4.
May I please, your Lordship, the matter relates to the pensionary benefit. The husband was expired, petitioner's husband was 13/6/2022, working as a draftsman in the houseboat. Thereafter, your Lordship, petitioner representatives have been placed before the authority, no response. Your Lordship.
Picked up. Heard Dr. B.N. Gogoi, learned counsel for the petitioner. The deceased husband of the writ petitioner was an employee of the Assam State Cooperative Housing Federation Limited, Beltola. That is the respondent number. Yeah, Beltola. Who is respondent number 4?
Second wife.
being aggrieved due to non-settlement of retirement dues payable to the deceased husband of the petitioner. She has approached this court by filing the instant writ petition. First of, it appears that there is some dispute between the petitioner and the respondent number 4, that is the second wife, regarding entitlement to receive retirement dues of the deceased husband of the petitioner. First of, issue notice returnable in 6 weeks. You are appearing for whom?
Respondent number 123, Lordship.
Mr.
I'm proxy counsel on behalf of G. Bordole, Lordship. He is on leave.
Mr. G. Bordole, learned standing counsel, Assam Standing Council Cooperation Department, Assam, has appeared and accepted notice for. No, what is your name?
NJ Daimari, Lordship.
Eh?
NJ Daimari, Lordship.
This is so and so in play, representing Mr. G. J. Bordole. G. J. Bordole, right?
G. Bordole.
G. Bordole. Standing Council Cooperation Department, Assam, has appeared and accepted notice for respondent numbers 1, 2, and 3. As such, service of notice upon the said respondents is deemed to be complete in this case. Extra copies of the writ petition will be furnished to the learned standing council. Petitioner takes steps for service of notice upon the respondent number 4 by registered post.
And it's a blessing.
Wait, please, Your Lordship. The petitioner herein challenges the impugned order passed by the disciplinary authority, Your Lordship, wherein the petitioner was inflicted with an major penalty of reduction to lower grade as junior assistant LDA. Under the rule 7(4) of the Assam Disciplinary and Appeal Rules, and thereafter an appeal was filed before the appellate authority, which was also upheld the order of the disciplinary authority, which is at page. The first order is at page 53, Your Lordship.
Petitioner was serving under
Cooperative Society, Your Lordship, under as a junior inspector auditor of cooperative societies.
So here we'll issue notice.
Yes, sir.
Your name, please.
Miss S. Jane.
For Miss S. Jane, learned counsel appearing for the writ petitioner, assailing the order of penalty dated 24/3/2023, imposing the punishment of within course reduction to a lower service. Where is the order of penalty?
At page 53, Your Lordship.
Imposing the
Third paragraph.
reduction to a lower service, grade or post, unquote, as well as the subsequent dismissal of the departmental appeal filed by the petitioner. He has approached this court by filing the instant writ petition. First up, peruse the grounds taken in the writ petition. Stop. Mr. S.K. Talukdar, learned standing counsel, Cooperation Department, Assam, prays for some time to obtain instruction. Issue notice of motion returnable in 6 weeks. Since Mr. Talukdar has appeared and accepted notice for respondent numbers.
All the respondents.
For all the respondents, no formal notice is required in this case. Extra copy of the writ petition be furnished to the learned departmental counsel,
Oblige.
so as to enable him to obtain instruction. Yes.
Well, the petitioner herein had sought for invalid pension. He had to be discharged from service because of, my lord, a bipolar disorder, which is a psychiatric disease. However, my lord, there were instances of intake of alcohol also as per the medical report. And for that respect, my lord, his disability pension, invalid pension has been rejected, my lord. However, the episodes of alcohol intake, my lord, as per the medical report are occasional. And that has to be actually connected to his psychological disorder.
So we'll issue notice.
My
of
lord.
this. Heard Mr. B. Pathak, learned counsel for the petitioner, peruse the statements made in the writ petition. The petitioner, being aggrieved due to rejection of his prayer for grant of invalid pension. Is it called invalid pension?
Invalid pension.
Invalid pension within courts. Has approached this court by filing the present writ petition, seeking a writ of mandamus. Full stop. I have perused the grounds taken in the writ petition. Stop. Ms. B. Sharma, learned CGC, appearing for the respondent, prays for some time to obtain instruction and file affidavit. In view of the above, issue notice of motion returnable in 6 weeks. Since Ms. Sharma, learned CGC, has accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned departmental counsel so as to enable her to obtain instruction and file affidavit.
Obliged, madam.
May I please say, Lordship?
Yes,
Lordship, that my senior is out of station. So matter may be adjourned for today and maybe fix on next week.
on the prayer of learned counsel for the petition, and this matter stands passed over for the day. Mr. T.C. Chutia, learned standing counsel.
No, my
uh,
lord, government advocate.
Learned senior government advocate, additional senior government advocate Assam, as well as Miss D. Bora, learned standing counsel, Agriculture Department Assam, are present on behalf of the R. Bora, are present on behalf of the official respondents.
May it please, Lord.
Yes.
Lordship, the petitioner was appointed on contractual basis as operator under Jal Jeevan Mission. Lordship, kindly turn to page 12. In 2010, his father donated some land to the government matter for establishing, and as a general practice, he was appointed as operator. And he was continuing as such, he has undergone some training also.
Lordship, a copy has not been served to us, Your Lordship, so I'm not aware of this matter, Your Lordship. Yes,
Sir,
sir, the
copy
copy-
next week, we'll take it.
Yes, yes, my lord.
Take down. Heard Mr. T. S. Sharma, learned
Hmm.
counsel for the petitioner. Also heard Mr. R. R. Gogoi, learned standing counsel, PhD
PhD.
Department, Assam, who submits that no copy of the writ petition has been served upon it. In view of the above, copy of the writ petition be served upon. You have received,
Yes, I received, Lordship, on
Mr.
behalf of
Gogoi?
2 and 3.
appearing for the respond number
120.
I
may
bring for respond number
1 and 4.
1 and 4.
1 and 4. Register to list this case again after a week or in the next week.
Yes,
In the
my
next for
lord.
motion.
May I take for a date, my lord?
You tell when do you want it?
My lord, on 8th, my lord, if possible, my lord. And
You want it on 8th?
8th of January.
Register to list this matter for motion again on 8/1/2025.
Obliged.
May I please, Your Lordship?
Yes.
Lordship, the petitioners are rural technicians, Lordship, energy technicians. Lordship, they did their work, Lordship, and as per their circular, the respondent authorities deducted 800 rupees from their job fee, Lordship. And as per circular, those amounts shall be paid to the petitioner after completion of work 5 years, after completion of 5 years, Lordship. 2017, Lordship, since 2017, they were fighting for their subsidies, Lordship. And this honorable court passed an order. Thereafter, subsidies, some portion of subsidies were paid to them. Now they are not paying our portion monies, which they have deducted from our key fee, Lordship, 800 rupees per plant, Lordship. This is the only prayer, Lordship, since subsidy was partially paid, Lordship, after filing of the writ petition initially in 2017. After contempt, filing of contempt, they paid some amount, but they are not paying the deducted money, Lordship. This is the only prayer, Lordship.
How many petitioners here?
Six, Lordship. One is the widow of one RET, Lordship. In the meantime, he died. All are senior citizens, Lordship. And there is a report, Lordship, where it is clear that we were the RET, Lordship.
So who is appearing for the Union of India?
Their names are reflected in the court list, Lordship.
Are you appearing in this case, Ms. Baru?
She's there in CGSC, Lordship. I am on CGSC, Lordship. আপনার KVIC বায়োগ্যাস
Acha, we'll take it up after some time. You wait for a little while.
I don't know, 11.
That VC thing, na, you don't say anything, we'll call it up as the last item, that's all. Last item will just call it.
May I please, your lordship?
In this case, my lord, the petitioners appeared before this honorable court as because they are denied the benefit of Upenda's case, my lord. The petitioners are appointed towards 2009-10 as accredited engineer, contractual employee.
What is your case number? Read petition number?
7007. It is item 10, my lord.
Okay, so who is appearing in this case for the respondents? Are you appearing, Mr. Datta?
Yes, my lord. My lord, actually, in the mention memo, the 10 is mentioned. That is why I'm just calling the file, my lord.
So any case, we'll issue notice.
Yes,
here
yes, my
only.
lord, my lord. That can be done.
Heard Mr. S. Salim, learned counsel for the petitioner. Peruse the statements made in the writ petition. The primary grievance of the writ petitioners is to the effect that despite being eligible, they have not been paid the benefits as per their entitlement under the judgment of the division bench of this court rendered in the case of State of Assam versus Upendas due to citation to GDO. Mr. S. Datta, learned standing counsel, Panchayat and Rural Development Department, prays for some time to seek instruction. Issue notice returnable in 6 weeks. Since Mr. Datta has appeared and accepted notice.
1, 3, and 4.
Respondent numbers 1, 3, and 4, and Mr. B. Gogoi, learned standing counsel, Finance Department, Assam, for respondent number 2. Service of notice is deemed to be complete in this case. Extra copies of the writ petition, requisite in numbers be furnished to the learned counsel for the respondents. Register to list this matter again by reflecting the name of learned standing counsel for the respondents in the cause list.
I am obliged, my lord.
In this matter, I require some time to bring additional information on record, lordship.
You want a adjournment today?
Adjournment, lordship, for filing an additional affidavit. Otherwise, it's a case of non-allotment of marks of experience. Yes,
Right.
from
On the request of Mr. B.P. Bora, learned counsel for the petitioner, this matter stands adjourned for a week so as to enable him to file an additional affidavit bringing certain relevant facts on the record of this case. List the matter accordingly.
May I please? The petitioner applied for paramilitary forces, my lord. Result, my lord, obtained, my lord, on 13/12, my lord. The petitioner, my lord, applied in economically weaker section, my lord. The persons, my lord, secured less mark than my lord, petitioner, they got selected. The result sheet, my lord, at page 93. At least in 4 category, my lord, the persons, my lord, secured less marks. In BSF, CISF, CRPF,
So would you like
ITPP.
to obtain instruction here?
Yes,
next week?
Lordship, our result had already declared, Lordship, and
All
therefore
right, you obtain preliminary instruction, we'll post it next Friday for motion.
some time required, Lordship, next month or last week of January.
As in Lordship.
Then we'll issue notice. We'll issue, heard Mr. S. Chauhan, learned counsel for the petitioner. Peruse the statements made in the writ petition. Pursuant to the advertisement notice dated 24/11/2023, the writ petitioner had submitted his candidature and participated in the recruitment process initiated for appointment of Constable (GD) in various central paramilitary forces as a candidate belonging to the economically weaker section (EWS). The grievance of the petitioner is that although he had fared well, FARED, fared well in the selection process and was entitled to be selected, yet his candidature was not considered. Stop. On the contrary, persons belonging to the same category and scoring lesser mark than the petitioner has been allegedly selected by the authorities. Stop. Hence this read petition. Stop. Ms. S. Barua, learned CGC, appearing for the respondents, seeks time to obtain instruction so as to respond to the allegations made in the read petition. In view of the above, issue notice of motion returnable on 10/2/2025. Since Ms. Barua has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the read petition, requisite in numbers, be furnished to the learned departmental counsel so as to enable her to obtain instruction. List accordingly. None appears for the read petitioner when the matter is called up, passed over for a week.
Item 16.
May I please, your lordship? Lordship, in this case, all the petitioners are first-class legal heirs of and victims of martyrs of Assam movement who died while participating in the Assam movement. Accordingly, Lordship, they are entitled to seek preferential appointment under the rules of Assam Public Service Preferential Appointment Rules 1999. Yes, sir, Lordship, they multiple times applied in vacant grade 3, grade 4 posts of Assam government in various departments, but their candidature was not considered. After that, Lordship, they filed a group case before this honorable court along with other petitioners. Whereas, Lordship, this court upheld their entitlement to seek preferential appointment. They were observed and advised to go through the selection process of any examination which is conducted by state level recruitment commission or whatsoever. After that, subsequently, Lordship, they appeared and went through the selection process of an examination conducted by SLRC in the year 2022, Lordship. Page 47, admit cards are there, annexure 14, annexure 4, Lordship. But in that result, Lordship, their candidature was not considered. After that, Lordship, recently another examination was held. In the year 2023, the examination was held on 15/9/2024 and 27/10/2024. Annexures are given in annexure 13, admit cards of the petitioner. The result is not yet declared, Lordship, but they received some information from reliable sources that this time as well, their candidature will not be considered.
No, we received information from whom?
The office authorities, reliable information, verbal information.
Show me what is the amendment? Candidature will not be considered. Why they've participated in the recruitment?
They have participated, Lordship. They went through the selection process.
You can't file a case like this. You have to see, preferential will depend only when two persons have the same score. Then preference. You have to make him a party and say that he and I scored the same marks. I should have been given the preference.
Yes, Lordship.
But so where is this private? This petition is not maintainable now.
Yes, Lordship.
You withdraw it and you wait once the result is declared.
But Lordship, earlier also.
Otherwise, I'll dismiss it and your roads will be closed. I don't want to do it.
Kindly maybe given a 2-line direction to consider the rules while considering the.
No, it's rules they are bound to consider. You can be complaining when two persons scoring the same mark and the other person gets selected. Then only the preference.
Yes,
question will
Lordship.
come.
In the year 2022.
Preference doesn't mean even if I fail appointment. No, that's not correct.
But Lordship, in the year 2022 also, there was a similar examination was held, conducted by the SLRC. The petitioners participated. Their admit cards are annexed here. And at that time as well, Lordship, their candidature was not considered and not.
It's not considered. They were not selected.
Yes, Lordship.
They were not selected. This is not a guarantee of appointment. These rules do not guarantee appointment. This only says some priority, some preference will be given.
Lordship, if they wait for the
No,
result.
you understood the point.
Yes, Lordship, I understood.
You
Lordship, if kindly.
do your homework on that and come back. Otherwise, there is no
Yes,
case.
Lordship, kindly allow me to submit a order of this.
No, he is not understood because he is not listening. He's not even listening. to the question. This will. What is your name?
SS Ahmed, Lordship.
Mr. Ahmed, have you understood my query?
Yes, Lordship, I
You do some homework and come back. Otherwise, this kind of petitions we cannot entertain. These are all going to be unnecessarily clogging the court system. You don't have any case right now. Absolutely no case.
Lordship, I'll withdraw this, Lordship.
You want to withdraw. All right, but you come when the results are declared. If you can show that another person was given preference, then only you will have a case.
Same month,
Not otherwise. All right, on the request of Mr. S.S. Ahmed, learned counsel for the petitioner, this writ petition
Lordship,
is
kindly these lines may be added in the order and I will dismiss, maybe dismissed it and.
That means he want to order the page 44. In that view of the matter, I see no merit in the present writ petition and same is accordingly dismissed. Notwithstanding the dismissal, that is this part he wants.
notwithstanding the dismissal.
Notwithstanding dismissal, the petitioner would be entitled to apply for the post under rule so and so, as and when the appointment is sought for,
Not
to
this
be
part,
made through
Lordship.
the public service
The last
commission.
two lines that.
Otherwise, as
rejected.
provided also, that this issue regards as to the whether the petitioner had a family members of the martyrs may also be examined by the authority concerned. That's so observation is there only.
All right. What do you want?
Lordship, the two lines just, your
What are the
Lordship
two lines
said
then?
that after the result, if there has been seen that other person have got similar marks and they.
Liberty to approach.
Yeah.
All right, we'll give you that.
Yeah.
Mr. S.S. Ahmed, learned counsel for the petitioner seeks leave of this court to withdraw the writ petition with liberty to approach once again as and when a fresh cause of action, comma, if any, comma, that may arise after the declaration of the result of the selection process. Mr. T.C. Chutia, learned additional senior government advocate Assam is present for the state and does not have any objection if the prayer is allowed. In view of the above, this writ petition stands disposed of on withdrawal with liberty as prayed for. But you must study on this
Yes,
point. Huh? Don't just rush to the court. Yes.
Deeply.
Oblast.
May I please? Question, this is civil bench two matter, madam.
It is submitted to the bar that this matter pertains to civil bench 2 and therefore it has been wrongly listed before this court today. Register to verify and list the matter before the
Most
appropriate bench.
May I please your lordship? Lordship, it is a matter of pension. Actually, it is a result of an earlier writ petition, whereas the court allowed the petitioner to grant family pension for the period of 2016 to 22. Whereas there is a daughter of the deceased husband of the petitioner, but the respondent authority sent the total amount to the account of the respondent number 7, that is the daughter. She is a daughter from the first wife of the husband of the petitioner. And recently we received an communication from the department, whereas they realized their mistake and asked the respondent number 7 to deposit the half of the amount to the petitioner. So we need some further time to talk with the respondent number 7. If she voluntarily gives us the amount, then we will withdraw this writ petition letter.
See, matter relates to family pension. And she wants her share. Second wife. First wife expired. Daughter is there, daughter is drawing the amount. Now she would like to claim as she is.
All right, then we'll have to issue notice here.
Notice.
Lordship, this is the communication. Lordship, my parents.
Correct, we'll issue notice, you take steps, then we'll decide. Your name, please?
Ivy Hussain.
Ivy?
Hussain.
Heard Miss Ivy Hussain, IVY, Ivy Hussain, and counsel for the writ petitioner. Whereas the statements made in the writ petition, the dispute raised in this petition pertains to entitlement to receive family pension. The case is contested by the second wife of the deceased employee vis-a-vis the right of the daughter from the first marriage, namely the respondent number 7, who, comma, it is alleged, comma, has been wrongly granted the benefit, wrongly granted the service benefits. Full stop. The issue raised in this writ petition can be adjudicated only after proper service of notice upon all the respondents. As such, issue notice returnable in 6 weeks. Mr. D.C. Bora Lanet, CGC, has appeared and accepted notice for respondent numbers 1 to 6.
1 to 6.
As such, no formal notice is required to be sent to the said respondents. However, extra copies of the writ petition be furnished to Mr. Bora within a week from today. Stop. Petitioner to take steps for service of notice upon the respondent number 7 by registered post with AD within a week. It is made clear that the disbursement of any amount of family pension, stroke, retirement dues in favor of the contesting parties during the pendency of this writ petition shall be subject to the final order that may pass in this case.
Obliged, Lordship.
Item 19.
May please your lordship. Matter relates to seniority and promotion lordship. Your lordship has challenged the seniority list lordship by which the name of the petitioner is placed much below than the other person lordship who are junior to me lordship. And for non-consideration my promotion to the post of UDA lordship.
Someone junior to you has been promoted?
Not promoted lordship, only the list was published lordship. Annex are 7 page.
No. Are you saying someone junior to you has been placed above you?
Yes, lordship.
But you have not made him a party.
Lordship, no, I have not made them party.
Then this writ petition will not be maintainable.
Then I will be allowed to make them party lordship because 5 person are junior to me. They were promoted.
I think you should withdraw and file a fresh because just adding them party will not help. You have to have pleadings.
Yes,
ready.
then I will be allowed to withdraw lordship.
Otherwise, this kind of a claim without them, it cannot be adjudicated. It will be dismissed after 2 years.
With a liberty to file a fresh.
Yes, on the request of Ms. P. Bhattacharya, learned counsel for the writ petitioner, this writ petition stands disposed of on withdrawal with liberty to file afresh after rectifying the defects in constituting the writ petition. First up, Mr. Ardhar, learned SCPWD, is present on behalf of the respondents.
Obliged.
Item 20.
May please your lordship. Case of compassionate appointment lordship.
Compassionate appointment.
Lordship.
Compassionate appointment is closed now.
Yes, madam.
Is this scheme still there?
Lordship, the further in the year 2018,
Lordship.
but in the year 2017, there is a scheme in lieu of compassionate appointment. It's a compensate family pension. Lordship, this in the year 2017, it's been stopped.
So, are you claiming compassionate family pension?
No, only appointment.
Appointment cannot be
Yes.
made.
Lordship.
You file a petition, you make a demand for compassionate family pension. If they don't pay you, come to the court.
Lordship.
You withdraw this.
Lordship.
All right. Mr. R. Fukan, counsel for the petitioner, who submits that the petitioner be granted leave to withdraw the writ petition with liberty to pursue appropriate legal remedy, including submitting a representation before the authorities for grant of compassionate family pension. Stop. The prayer is not opposed by Ms. M.D. Bora, learned standing counsel transport department.
For all the respondents.
Appearing for the respondent. In view of the above, this writ petition stands disposed of with liberty as paid.
Obliged.
Item 22.
May please the lordship. I let petitioner challenge the notification of compassionate appointment. At this stage, let notice may be issued lordship because she was selected by the DLC, but by virtue of that notification lordship. So petitioner is now challenging that notification lordship. So I pray lordship, other matters are also pending. lordship.
Petitioner is challenging which notification?
Notification dated 18/9/24 lordship.
Yes, what is the notification? Let us see.
Notification is lordship. Page 53 lordship, annexure 5.
Page
That is
53.
lodged. Last paragraph lordship. In view of the circumstances, it has been decided that no case for appointment on compassionate ground to the family members of the state government employees lodged. Our case was already recommended by the ALC lodged. And some of the other similar matter, Lordship, this honorable court needs to issue.
What is the similar matter? What is?
Lordship, I am supplying this. I have also annexed one order also.
Which page? Tell me the page number. Earlier order.
Earlier, that Lordship, sir. Page 60, Lordship. That order I could not annex, subsequently I got it, Lordship. Same set of cases, Lordship. Notice was issued, Lordship.
No, this is not this notification. That is 17/4.
Yes.
1/4/2017.
Lordship. Then I
This is
also,
another notification. That is where the scheme itself has been dispensed with. Yours is no government servant can be.
that scheme already, Lordship, I have also first paragraph, that scheme, Lordship, already closed, Lordship. 18 September 20, reviewing the scheme for appointment
So
of family.
please try to understand what I'm.
Lordship, Lordship, please.
These orders you are showing,
Lordship.
these were passed in another batch of writ petition where the scheme, withdrawal of the scheme was challenged.
Lordship.
You are aggrieved by the ban of government servants relatives to be appointed on competition.
Lordship, no, I am also challenging the same, Lordship. That notification, Lordship, page 59 is the same order, Lordship. 60 is the observation. 61. 61. 61, Lordship. 60 and 61, Lordship.
All right, what do you have to say?
Lordship, note, Lordship,
Mr. K. Majumdar,
yes,
I
in
counsel
that-
for the writ petition appears the amendments made in the writ petition. The petitioner is aggrieved by the notification dated 18/9/2024 issued by the Personnel bracket B bracket close Department, Government of Assam. Imposing restriction on appointment of family members of government servant on compassionate ground. What is the meaning of this? Family member of government servant means government servants member can only be appointed. What is the meaning of this? Huh? Non-government servant, they will get compassionate appointment. Then Mr. Majumdar submits that the petitioner was selected by the SLC.
DLC, Lordship.
By the DLC prior to issuance of the notification dated 18/9/2024. Moreover, the impugned notification is completely irrational and therefore deserves to be set aside by this court. Mr. Majumdar has also referred to the order dated 30/9/2024 passed in WPC number 5067/2024 to submit that similar issue raised in that writ petition is pending disposal before this court. Mr. J.K. Goswami, learned additional senior government advocate Assam, appearing for the state.
1, 2, 3, and 6.
Instruction. Issue notice of motion returnable in 6 weeks. Since Mr. Goswami has appeared and accepted notice for respond numbers
1, 2, 3, and 6, Lordship.
1, 2, 3, and 6. And Mr. R.R. Gogoi, learned standing counsel, Forest Department, Assam, for respond
4,
numbers
5, and 7.
4, 5, and 7. Service of notice would be deemed to be complete in this case. Extra copies of the writ petition, requisite numbers be furnished to the learned standing counsel appearing for the department. Office to list this case again along with WPC number so and so by reflecting the name of learned counsel for the respondents in the cause list. But this is a bad notification. The language is bad. You must point it out. Compassionate appointment is given only to the family members of government servants. Then who else will get it? Yes.
May I please, your lordship?
Yes.
This case relating to promotion, my lord, from the post of senior assistant to the labor inspector. The petitioner initially appointed, my lord, grade 3 post, junior assistant. Thereafter, he was promoted to the post of senior assistant. The problem is that, my lord, one amendment was made based 26, your lordship may kindly see. Page 26. On 26th of July 2007, a notification was issued, amendment of Rule 6. For clause A, the following shall be substituted, namely 35% of the post to be filled up at a time in the cadre shall be made by promotion in accordance with Rule 7 at the ratio of 50-50 from among the cadre of ministerial government servant of the labor commissioners establishment and other ministerial junior staff of the subordinate rules offices under the Labor Commissioner Assam on separate gradation list who have rendered at least 10 years of service and who have not crossed 45 years of age on the first day of January of each year in which the promotion is considered. Earlier, my lord, prior to that, 2007, there was no, my lord, such condition.
Mr. Secretary Counsel for the writ petitioner, where was the amendments made in the writ petition? The basic prayer of the petitioner in this case is that his, before the petitioner who was originally appointed on compassionate ground in a grade 3 post in the office of Labor Commissioner, Assam, has approached this court seeking a writ of mandamus directing the respondents to consider his case for promotion to the post of labor inspector by relaxing the upper age limit. Full stop. Mr. J.K. Goswami, learned additional senior government advocate Assam, submits that the prayer made in the writ petition is not maintainable. However, he seeks some time to obtain instruction and respond to the allegations made in the writ petition. In view of the above, issue notice of motion returnable in 6 weeks. Since Mr. Goswami has all the respondents has appeared in accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned government advocate Assam. It is made clear that pendency of this writ petition shall not constitute a bar for the authorities to redress the grievance of the petitioner in accordance with law, if so advised.
Only two conditions, my lord, that Governor of Assam, my lord, he has the authority under the rules for relaxation. Just I'm submitting, and my lord, many other persons who has crossed, my lord, 45 years, after that has been 2020, they have been
Bearing in
promoted.
mind
Now, my lord,
past
I'm
precedent
pray
in
for
the
all
matter.
posts vacant, my lord, because they are crossed other
Given the
posts,
liberty.
all posts. Item 25 also, my lord, same, but he was recruited after due interview and my lord selection.
Grade 3 post.
He is working, yes, my lord.
Great.
As senior, yes, my lord.
Great.
Earlier he was appointed junior assistant, now he is working as senior assistant.
And this case petitioner is working as
Senior
in present
assistant.
case
Senior assistant.
at a line level. Petitioner initially recruited grade 3 post on compassionate ground and is presently working in the post of senior assistant. In item 25 also similar list along with this.
24 not my lord, 25
Five.
is also
Yes,
similar.
yes, 25 is similar.
Obliged.
23 lower. Just check it once from the
Obliged.
past precedent, precedent. Precedent law, past practice, if any, past practice. Yes, what is this matter?
Your lordship, the subject matter of this case is once the petitioner was directly been removed from the service based on a criminal case which was pending before the learned special judge NDPS. And for which the disciplinary proceedings was initiated and after which he was not been given any opportunity of being heard and following which we approached this court and the court passed an order in favor of us. The order is at page 36.
Yes.
Forty-seven is the last page of the order, if I may read the relevant portion.
Yes.
The respondents are directed to reinstate the petitioner within a period of 4 weeks from the date of receipt of certified copy of this order. The respondent may thereafter proceed against him in accordance with law, if so advised, after giving the petitioner an opportunity to show cause. In doing so, it will be open for the authorities to place the petitioner under suspension if deemed necessary. After which your lordship may just find a letter at page 48, for which I was a letter was issued a letter was issued against me to join the duty immediately. This is the joining letter at page 48. After that, the petitioner joined the service, and after a few days at page 49, I was placed under suspension, and the disciplinary proceedings again was initiated. But now, where in this disciplinary proceedings, what circumstances was I had to face is, no doubt there a reasonable opportunity was been given to me. I submitted my representation, everything was done. But in the meanwhile, we also got acquittal from the court on the basis of benefit of doubt. We are also aware of that the benefit of doubt is not a clean sheet, and therefore we cannot claim reinstatement. So that is another subject matter. But however, in this disciplinary proceedings, what discrimination we had to face is the charges which are there in the criminal case are exactly ditto in my disciplinary proceedings. Further, the inquiry officer in the preliminary inquiry prior to we approach this court. So in the preliminary inquiry, the inquiry officer of an ASC rank, Assistant Security Commissioner. Simultaneously, in the subsequent disciplinary proceedings, what happened is an inspector rank officer has been appointed as an inquiry officer, which is contradictory to their own circular. The circular is at page 155.
But what is now the inquiry?
Lordship, issue notice, let us file a reply, Lordship. Yes. Appeal has also been rejected, Lordship.
He has been again removed from service.
He again been removed from the service.
But lead the examination, Lordship.
Will issue notice that.
Yes.
Third, MSSB Barua bracket TG bracket close appearing for the writ petitioner. Peruse the statements made in the writ petition. The order dated 16/12/2023 by means of which the petitioner was removed from service, and the subsequent order dated 02/04/2024 rejecting the appeal filed by the petitioner have been put under challenge by inter alia alleging that there has been serious violation of procedural safeguards while conducting the disciplinary proceeding. Full stop. Mr. B. Chakravarti, learned CGC, appearing for the respondents, has prayed for some time to obtain instruction in the matter. Issue notice of motion returnable in 6 weeks. Since Mr. Chakravarti has appeared and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned CGC so as to enable it to obtain instruction and file affidavit. Since it is a case of removal from service, there is some urgency involved in the matter. As such, this court will consider expediting hearing and disposal of the writ petition on the returnable date.
Lordship, returnable
6 weeks.
More interestingly, the Assistant Security Commissioner under whose supervision all these proceedings happen, he is also facing the inquiry proceeding.
Good.
Not of a clean image.
Item 26.
There is some urgency in the matter. Therefore, this court will consider the request for expediting final hearing and disposal of the writ petition on the returnable date.
May I please, your Lordship? My Lord, dispute relating to this petition, my Lord, the quantum of pension. The petitioner has been paid pension, but he has been paid lower pension, my Lord.
Take down. Will issue
Notice may
notice,
be
sir.
issued.
Heard Mr. M. Islam, learned counsel for the writ petitioner. The dispute raised in this writ petition pertains to quantum of family pension. Family pension presently being received by the petitioner. First, Mr. S. Dattal, understanding counsel, Panchayat and Rural Development Department, prays for some time to obtain instruction. NOM 6 weeks. Since Mr. T.C. Chutia, learned additional senior government advocate Assam, has appeared and accepted notice for respond numbers 2 and 5 and Mr. S. Datta, learned Standing Council, Panchayat and Rural Development Department, Assam, for respond numbers
1, 4, and 6.
1, 4, and 6. Service of notice on the said respondents is deemed to be complete in this case.
Finance department is there.
Mr. A. Cholia, learned Standing Council, Finance Department, has appeared for respond number 7.
3 also.
Respond numbers 3 and 7. Therefore, no formal notice is required to be sent to the said respondents as well. You are not appearing for 6.
Also 6.
Yes, I'm appearing for 6 months. 1, 4, and
Therefore,
6.
service of notice is deemed to be complete in this case. Extra copies of the writ petition will be furnished to the learned department council so as to enable them to obtain instruction. Let this writ petition be listed again by reflecting the name of respective standing council or the official respondents in the cause list.
2 and 5 director of bank, 2 and 5 government appear, pension.
He is appeared.
Highly obliged, Your Lordship.
Should the petitioner contractual employee working under the PNRD department has been terminated from service for alleged misconduct without notice? Not even notice may go.
In this writ petition, the order of termination from service dated
14/5/2020.
14/5/2020 has been assailed by the writ petitioner. Stop. Issue notice returnable in 6 weeks. Mr. S, who is appearing for whom? Who peruse the grounds taken in the writ petition. Issue notice returnable in
1, 2,
Mr.
4, and
S.
5.
Datta, learned Standing Council, Panchayat and Rural Development Department, Assam, has appeared and accepted notice on behalf of respond numbers
1, 2, 4, and 5.
1, 2, 4, and
No,
5, and
three
Mr. H.
government
Chakravarti, learned G. Assam for respond number 3. Hence, post of the hence, service of notice is complete in this case. Extra copies of the writ petition, requisite in numbers, be furnished to the learned department council so as to enable them for.
Maintainability maybe because filed after 5 years almost. Contractual employee.
What admission you raise this? If there is explanation, then it can be. Yes. Yes, please.
Lordship 28 similar.
What is the date of? termination?
Date is also 27. 14/5/2020, Lordship. Similar.
List along with by party, array of parties same.
Yes, same.
Both of them are terminated on the same day.
Same date, Lordship. Oh, Lordship, here the release order is 1/7/2020. I'm sorry, 1/7/2020.
No, but
Second
order of termination.
release order 1/7/2020. The order of
There is no
termination.
order of termination. It's a release order.
Release order here in this case.
So, assailing the termination from service and the issuance of release order dated 1/7/2020. In the earlier case, release order is
14/5. There is no release order. There is a termination from service order 14/5/2020. Earlier case.
earlier case remains there and the release order here. List along with other matter.
Obliged.
Item 29.
Obliged.
Lordship, in this case, petitioner is aggrieved by the rejection of his case by the district level committee in its meeting dated 19/9/2023, Your Lordship, page 74, Your Lordship. And what happened, Your Lordship, petitioner's case was first considered in the meeting dated 3/4/2017, Your Lordship. In that meeting, Your Lordship, his case was not become because of want of vacancies, and his case along with 3 other persons was directed to be considered in the next meeting, and accordingly his case was placed on 23/2018, Your Lordship. In that meeting, Your Lordship, his case was rejected for want of vacancy. Then this petitioner approached this honorable court, Your Lordship, with WPC 8456/2018, Your Lordship, page 59, Your Lordship. And this honorable court directed to consider as per the office memorandum dated 1/5/2016, 1/6/2015, Your Lordship. Then, Your Lordship.
We'll dismiss it later. Because they will continue filing. He might have his other reasons. will dismiss this petition, but at the moment issuing notice, no compassionate appointment from this court. Question doesn't arise, and it will be wrong because the scheme is gone.
Not.
Scheme, it was under a scheme. That scheme is a power of the state for welfare measures to cut across Article 14. Once the scheme is over, absolutely over. You keep filing cases, that will keep the registry busy, and the judges will club everything and dismiss all the cases someday. Or if you are too lucky, then you might get an order which someday will again be set aside. How can you ask for a compassionate appointment when the scheme itself is withdrawn? I've been telling this again and again and again. People won't listen. You are again and again coming. Heard Mr. K. Miran and counsel for the petitioner. The relief sought for in this petition pertains to claim of appointment on compassionate ground. Mr. H. Chakravarti, learned government advocate Assam, has pointed out that the scheme itself has been withdrawn by the state with effect from 1/4/2017, and therefore the writ petition is not maintainable. Ms. M.M. Kutoki, learned standing counsel, Agriculture Department. Animal Husbandry Department, Assam, is present for the other official respondents. Be that as it may, in view of the submission made by the petitioner's counsel that similar writ petitions are pending disposal before this court, issue notice returnable in 8 weeks. Since Mr. Chakravarti has accepted notice.
3 and 4.
Since Mr. M.
125.
For 125 and Mr. Chakravarti for 3 and 4, service is complete, extra copies.
May it please your lordship. I'm working as the registrar of the Industrial Tribunal, Guwahati, my lord. My lord, the benefits of the Shakti Commission have been extended to the subordinate court staff, the non-judicial staff of subordinate courts, including Industrial Tribunal and Labour Court. However, my lord, the registrar has been left out. There was a recommendation by the Honorable Committee of this Honorable Court on the administrative side for equalization of pay of the registrars with that of Serisadars of the District Court. But that has not been acted upon, and rather, the government of Assam says that since the post of registrar is not mentioned specifically in the Shakti Commission's recommendations, he is not entitled. Therefore, I am before lordships.
Notice by issue, my lord, STC.
Heard Mr. P.D. Nair, learned counsel appearing for the writ petitioner, peruse the amendments made in the writ petition. First up, the petitioner herein is presently working as the registrar in the
Industrial
Tribunal, Guwahati, aggrieved by the non-payment of benefits ensuing under the Shakti Commission's recommendation by way of higher pay, which, according to the writ petitioner, have been extended to the Saristadars, to the equivalent post of Saristadars of the district and sessions judges establishment in Assam, the present writ petition has been filed. Mr. T.C. Chutia, learned additional senior government advocate Assam, has prayed for some time to obtain instruction in the matter. NOM 6 weeks. Since Mr. Chutia has accepted notice for respond numbers
1, 4 and 5.
1, 4 and 5.
6
Mr. P. Nayak, Mr.
N.K. Sharma, Lodge.
N.K. Sharma.
Correspondent number 2, 3 and 8.
2, 3 and
8.
8. And Mr. P. Nayak, Mr. P. Nayak for respond number, Standing Council Finance Department Assam for respond number 6. And Mr. R.K. Talukdar, learned Standing Council AG bracket ANE bracket close Assam for respond number 7. Service of notice is deemed to be complete in this case. Extra copies of the writ petition requisite in numbers be furnished to the learned department council so as to enable them to obtain instruction. Let the matter be listed again after 6 weeks.
Deeply.
Let's stop.
Maybe Lordship. My lord, the petitioners, my lord,
Before my learned friend starts, my lord, we have wrongly accepted notice, my lord. We are for the marketing division of IOC. This department doesn't have a standing council. Notice has to go. My lord, can you excuse my accepting the notice?
There is no standing counsel for the.
No, my lord, notice has to go. Yes, my lord.
Hmm. So what is your case?
My lord, case is that my lord, the petitioners did, my lord, under the Apprenticeship Act, they did the course of boiler attendant, my lord. Now, my lord, after that, they were issued provisional certificate, that is Annexure 1, page 16, 17, and 18.
Hmm.
The provisional certificate, it was correctly mentioned as a trade apprenticeship boiler attendant. But my lord, in the final certificate that is issued by the, my lord, Board of Practical Training, Annexure 4 onwards, it is mentioned as Bachelor of Science, my lord. That is the mistake that is committed by them.
Page number?
Page number, my lord, 19, 20, 21, my lord. There is no such course as Bachelor of Science, my lord, given under the Apprenticeship
All right,
Act, my lord.
take down. Heard Mr. I. Chaudhary, learned counsel appearing for the writ petitioners, peruse the averments made in the writ petition. The petitioners herein had participated in the apprenticeship training as trade apprentice bracket boiler attendant bracket close under the Indian Oil Corporation Limited Guwahati Refinery for the period from 11/2/2022 to 11/2/2024. Full stop. On completion of the apprenticeship, the petitioners were issued certificate of proficiency. Full stop. The grievances of the petitioners are identical, and the same relates to an alleged mistake in the proficiency certificate pertaining to the mention of the subject of apprenticeship. Full stop. Mr. Chaudhary submits that in those certificates, the subject has been mentioned as within quotes, Bachelor of Science, bracket B, full stop, SC, bracket close. Although there is no such subject for the
Under the Apprenticeship Act.
Under the
Apprenticeship
Act applicable in this case. Full stop. Hence this writ petition. Stop. Issue notice of motion returnable in 6 weeks.
Well, actually, we have another issue, my lord. Actually, after completing this course, my lord, we have applied for an advertisement was issued, my lord. An advertisement issued, that is Annexure 9, page 27, for the post of Junior Assistant 4. And as per this, the qualification was, my lord, BSc along with boiler competency certificate or second class. So we had that qualification. But after we applied for the said post, we were also issued admit card for the written test. But later on, we came to know that as we did not have that certificate, corrected certificate, so we were not selected, my lord.
Achha, then wrong mention, really. Then you write, according to Mr. Chaudhary, due to such error in mentioning the correct subject in the proficiency certificate, his clients were denied appointment in a recent selection procedure conducted for recruitment of boiler attendants.
Junior Engineering Assistant.
Hence,
4.
this recruitment of junior
Engineering Assistant 4. Page number, my lord.
Engineering Assistant, grade 4. Page number?
My lord, page number 27, postcode 202, my lord.
Junior Engineering Assistant dash Roman 4 bracket P and U. Stop. Hence this writ petition. Issue notice of motion returnable in 4 weeks. Petitioner to take steps for service of notice upon the respondents by registered post with AD. Do you have any interim?
Yes, we have interim that at least 3 posts may be kept vacant, my lord.
Hard on the prayer of interim relief, the said will be considered on the returnable date. However, considering the overall facts and circumstances of the case, it is made clear that recruitment stroke appointment orders issued with regard to the post of so-and-so during the so-and-so shall be subject to final orders that may be passed in this case. Subject to the final orders. If any, shall be subject to. However, as an ad interim measure, yes. Yes.
May I please, Lordship, this is compassionate appointment, my lord. I challenged my lord office memorandum dated 18/9/2024, my lord. Lordship, this honorable court.
Mr. Your name, please.
H.L. Lashkar, my lord.
H.L. Lashkar, and counsel for the petitioner, peruse the amendments made in the writ petition. The notification dated 18/9/2024, issued by the Personnel B bracket Department, Government of Assam, dispensing with the scheme of compassionate appointment to be granted to the family members of deceased government employees have been put under challenge in this writ petition. Mr. Lashkar submits that similar writ petitions have already been admitted by this court. Ms. D.S. Nayog, learned Standing Council Irrigation Department, Assam, and Mr. A. Chakravarti, learned G. Assam, appearing for the state, have both prayed for some time to obtain instruction in the matter. NOM 6 weeks. Your four respond numbers?
1, 1, 4, and 5.
1, 4, and 5. And Mr. Chakravarti?
2,
2 and 2, 3 and 7 also.
2, 3, and 7. What about 6?
This is 6 I am appearing.
2, 3 and the remaining, sir? No formal notice,
Yes,
extra
sir,
copies of the writ petition. Let this matter be listed again after 6 weeks, along with similar writ petition. Along which is similar?
This matter, WPC 5067, public 2024.
Along with WPC number 5067 of 2020.
Most obliged.
My please, Your Lordship. Herein, Your Lordship, the petitioner, he participated in the recruitment process for the post of Constable AB. But the candidature of the petitioner was rejected on the ground of having found that the petitioner was found short height than the required height, Your Lordship. In page 28 is that.
Next Friday, you tell us what has happened
Not so.
for motion. Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. H. Chakravarti, learned. You are appearing as?
All the respondents.
CGC.
No,
Sir.
Assam,
G. Assam appearing for the state. To 6 posting of this matter again on next Friday. What is the date? 10th of January 2025 for motion so as to enable him to obtain preliminary instruction pertaining to the grievance expressed in the writ petition. Prayer allowed. 2 extra copies of the writ petition be furnished to Mr. Chakravarti. Office to list this case again for motion on 10th, 2020.
Obliged.
36.
May please, Your Lordship. May please, Your Lordship, my lord. Petitioners participated for the post of my lord, Central Armed Police Forces, my lord. And they got the cutoff mark, but their result has been kept withheld due to mismatch of biometric data, my lord.
Preliminary instruction. Letter next Friday.
My lord.
Heard Mr. H.R. Raman, counsel for the petitioner, peruse the statements made in the writ petition. According to the petitioners, their results have been withheld due to mismatch of biometric data, despite the fact that the petitioners have scored the cutoff mark. Ms. S. Sharma, learned Ms. B. Sharma, learned CGC, appearing for the respondents, has sought posting of this matter again on 10/1/2025 so as to enable her to obtain preliminary instruction responding to the allegations made in the writ petition. Prayer allowed. Office to list this matter again on 10/1/2025 for motion. 2 extra copies of the writ petition be furnished to Ms. Sharma during the course of the day.
I'm getting motion letter item 11.
Madam, here I don't represent the commission, madam. I only represent the board. Madam. Then notice has to go.
1 and 2. For 1 and 2. I am appearing for 1 and 2.
Heard Miss S. Kanungo, learned counsel for the writ petitioner, perused the amendments made in the writ petition. It appears that the petitioners and oblique or their predecessor in interest. Some husband are also there.
No, Lordship, 5 are the RAT and 1 is the husband, wife of the deceased RAT, Lordship.
The writ petitioner numbers.
1 to 5 are the RAT,
It appears
Lordship,
that the writ petitioner numbers 1 to 5
or RAT.
are were engaged as rural energy technicians bracket RET, whereas the husband of the respondent number 6,
Petitioner number 6.
petitioner number 6 was also engaged as RET, who worked under biogas plants under the National Biogas and Manure Management Program, aggrieved due to non-consideration of their prayer for refund of rupees 800 kept as caution money. The petitioners have approached this court by filing the instant writ petition. Instant writ petition seeking a writ of mandamus. Ms. S. Borua, learned CGC, has prayed for some time to obtain instruction in the matter. Issue notice returnable in 4 weeks. Since Ms. Borua has appeared and accepted notice for respondent numbers
1 and 2.
1 and 2, no formal notice is required to be sent to the said respondents. Extra copies of the writ petition will be furnished to the learned departmental council within 3 days from today. Petitioners to take steps for service of notice upon respondent numbers 3, 4, and 5. The registered post with AD.
Please.
For admission, 38.
May it please your lordship. My lord, the petitioner, he was initially appointed under the municipal administration.
Mr. SP Chaudhary, my lord, currently is not available. Can this matter be fixed too, my lord? Mr.
Not
SP
available.
Chaudhary,
Who's not available?
Mr. SP Chaudhary for Assam Urban Water Sewerage Board, my lord.
2 o'clock.
2, sir.
Then we'll do it on Tuesday.
Yes, lord.
Heard Mr. Kiran Chaudhary, and Senior Counsel appearing for the writ petitioner. Also heard Mr.
K. Vishwakarma, my lord.
K. Vishwakarma, who submits that the arguing counsel appearing for the
Assam respondent number 2 and 3.
respondent numbers 2 and 3 is not available, and therefore the matter be taken up again on Tuesday, that is 7/1/2025.
My lord, my junior says on 7, so many matters are fixed. So could it be after vacation, Bihu vacation on 21st, my lord?
Not available. And therefore, this matter be listed again immediately after the reopening of due vacation. The prayer is not opposed. Mr. Chutia, learned additional senior government advocate appearing for respondent number 1, and Mr. D. Bhattacharya, learned counsel for the respondent number 4, are also present. On the request of the learned counsel for the parties.
Let it be at 2-0, my lord, if it is not inconvenient. 2-0.
This matter stands adjourned. Registered to list this case again on 20th of January 2025 as a fixed item subject to availability of balance.
Applies, my lord.
Item 39.
May I please your lordship?
Yes, yes.
The engaged counsel, Mr. M. Sharma, is out of station, lordship. I am praying for an adjournment today. The affidavit has been filed, lordship.
So we have to file an affidavit and reply. 1 week time maybe can.
You want to file reply?
1 week time may can, 1 week or 2 weeks? 2 weeks.
2 weeks. Mr. A. Dasgupta, learned senior counsel appearing for the writ petitioner submits that a copy of the counter affidavit filed on behalf of respondent numbers 1 to 5 has been received, and therefore the petitioner be granted 2 weeks time to file rejoinder. Prayer is not opposed by learned counsel for the respondent numbers 1 to 5. Miss
S. Yasmin.
S.
Yasmin.
Yasmin. In view of the above, let this matter be listed again after 2 weeks.
Okay. Any date may kindly be fixed.
After 2 weeks, after the BU vacation.
Deeply obliged.
Lordship, matter relates to promotion of the petitioner to the post of Assistant Secretary. Lordship, he completed 4 years in the post of planning officer and attained eligibility for promotion to the post of Assistant Secretary on 25/2020. Now, on that date, there was a vacancy. But instead of holding a DPC and considering him for regular promotion, they have kept the post occupied on ad hoc basis, which is violative of DOPT circulars which I have enclosed. Now, Lordship, in this matter, they have also filed a reply. I have also filed my affidavit in reply and also an additional affidavit. Now, Lordship, matter can be taken up for disposal today because there is an urgency. Man is due to retire in the month of February, Lordship. So, what has happened, Lordship?
No, today we'll not take it up, but you can choose a date on a hearing day, non-miscellaneous. Today, first matter, a hearing, this is to be admitted. So we can take it up next week, Thursday.
Lordship, Tuesday, Lordship.
Thursday?
Thursday, Lordship, I've got some difficulty, Lordship. Any other date, Lordship?
Maybe
Let us
Tuesday,
go
Lordship.
Thursday.
Maybe Tuesday.
So what is the urgency here?
Urgency, man is due to retire in the month of February.
Which man?
Petitioner.
Ah.
And there is a prayer for interim also, ad hoc promotion. Ad hoc promotion, they are granting to his.
You want promotion from this court? That you will not get.
Direction for consideration for promotion to the post of Assistant Secretary from the date of vacancy and the date on which there was eligibility. Also.
Show me a law which permits that. That's not permissible. Show me the law.
Lordship,
We'll finish it off today itself. Give me the judgment.
My
Which
junior is holding the post of Assistant Secretary on ad hoc basis.
Ah.
So my claim for regular promotion is my final prayer, and my ad hoc promotion is on interim basis.
First of all, ad hoc promotion will not even consider. That's not the prayer. Promotion, the law is very well set. You are also connected with this case. Please take your seat. What are you doing here? Only relief that the court can grant is for consideration of promotion. Nothing else.
Yes, Lordship.
We'll ask them to consider your case for promotion subject to eligibility. That's all. What are the relief? These reliefs cannot be granted.
I had submitted representation. They had considered my representation and rejected it. And their ground which they have taken, the impugn order.
Let us see.
The impugn order is at page 108. 108.
108. What is there?
108. They have stated they have not considered my prayer for regular promotion. Regarding ad hoc promotion, they simply say that the incumbent to whom they have given charge on ad hoc promotion, that man is in the same office where there is a vacancy.
Mr. Sharma, I am warning you. It seems you are not aware of the jurisprudence. You are just cribbing about your client's problem. We are concerned about what is the case accordance with law that is made out. These are none of these submissions will be considered by the court. What is your case? You have to tell it.
Yes.
The law regarding promotion is clear after Ajit Singh too.
Yes.
You have to fit in your case on that.
Yes.
Ad hoc promotion has nothing to do with the matter. We will not even consider. If ad hoc promotion is your argument, we'll dismiss the writ petition.
No, ad hoc promotion, I'll come, Lordship, with your lordship.
Ad hoc promotion, we cannot argue. We will not grant it.
Yes.
Regular promotion, what is the problem? Tell us.
A regular promotion. A regular promotion, they have they have not stated anything in this impugn order. They have not considered itself. And today, Lordship, in their reply, they are stating that that post has been deemed abolished. They are saying that the post is remaining vacant for a period of 5 years. So the post has become deemed abolished. But my humble submission is that, Lordship, the post is not vacant. Due to the operational and functional requirement of the post could not be kept vacant. It was kept occupied on ad hoc basis due to the requirement of the post. So it was not vacant. So, and secondly, they are saying that the date on which the post became deemed abolished, my eligibility is even prior to that. So even assuming that the post was deemed abolished on the date which they have mentioned in their affidavit in opposition, my eligibility is prior to that. And if your Lordship will see regarding abolition, abolition, I have enclosed one restructuring proposal in my additional affidavit that your lordship will find at page running page 121. 121. That is a proposal of restructuring submitted to the Under Secretary Ministry of Commerce for approval. Page 121.
R.K. Deep Chaudhary, we will fix the matter on 21st for final hearing, but he has not been able to make out any case. We just wanted to give him,
in
because
fact,
he is arguing everything which
This
has
is-
nothing to do with.
This is not the first round of litigation, Lordship. It was agitated earlier also.
The petitioner may have a grievance, but what Mr. Sharma is arguing, these are not matters for the court to get in. We can only look into violation of Article 14 and 16.
It is
Post
only up to
abolish,
consideration.
post created,
Lordship,
none of the
Up to
business of the
consideration,
court.
Lordship can vary it.
Lordship,
Only up to consideration.
That too, if he can show that he is in the zone of consideration. So I am again and again hinting at him,
Lordship,
so whatever he has argued so far,
Lordship,
none of this has anything to do with a writ petition.
Lordship, my right for consideration
Do you want
promotion,
to finally argue it today?
can it be in the first week on Thursday, Lordship?
Nothing. Either you do it today or on 21st. Which do you want? Today final argument?
Today, Lordship may
Okay.
take it.
All right.
Lordship will have a page 41, Lordship. Page 41.
Page 41.
Page 41. This is my promotion to the post of planning officer. The undersigned is directed to state that in pursuance to the judgment of the Honorable Kolkata High Court, recommendation of DPC held on so-and-so regarding filling of the post of supply officer, now redesignated as planning officer, has been reviewed by DPC, and on review DPC Ujjal Kanti Pandit, security officer, now redesignated as estate officer for promotion to the post of supply officer. On 25/2016, he was promoted to the post of supply officer, redesignated as planning officer on 25/2016. Now, eligibility for promotion to the post of to the next promotional post that your lordship will find.
So how long will you take? Admission means 10 minutes.
10 minutes.
10 minutes, not beyond that. Yes.
Now, lordship will see the rules, lordship. Page 44. Page 44, rules.
Yes.
Rules, next promotional post. Page 47, operative portion, assistant secretary. Assistant secretary. Page 47, assistant secretary. Post is 1. Number of post is 1. Whether selection post, non-selection post, it is selection post. Then next page 48, the feeder cadre. 11 column. 11 column. From the cadre of joint controller, licensing or planning officer. Now, planning officer is one of the feeder cadre. Feeder cadre. A planning officer or welfare liaison officer with great pay, so-and-so, with 4 years regular service. 4 years regular service. So I have obtained eligibility on completion of 4 years on 25/2020. 25/2020 is my date of eligibility. Now, lordship will see.
Date of eligibility to become?
Assistant secretary. (25/2020) eligibility to become assistant secretary. Now, next page, lordship will see vacancy I will satisfy. Vacancy page 50. Assistant secretary, only one post. I am the senior most person in the feeder cadre that is admitted, lordship. Page 50, vacancy. Undersigned is directed to say that Sri Subrata Banerjee, system analyst. Sorry, lordship, page 49, 49, vacancy. Vikas Kumar Biswas, assistant secretary, will attain the age of 60 years on 14/11/15 in terms of so-and-so. He will superannuate from the service of the board with effect from afternoon of 30/11/15. Means on 30/11/15, there is a vacancy. There is only one post of assistant secretary. I have shown lordship the rule position, page 47, one post. So Vikas Kumar Biswas, he has retired on 30/11/15. So on 30/11/15,
We will ask them to consider your case if you are eligible. Any vacancies are available. That's the only order we can pass. Whether post has been abolished or not, that decision is not possible today. You want a decision on that?
For a moment, Lordship may peruse, Lordship,
So you
my
want a
submission.
decision whether the vacancy is available or not, whether it has been abolished, despite abolition, whether it is, these are the points you want decision.
Abolition, Lordship, they are saying that it is deemed abolished. Deemed abolished.
So you want a verdict from the court on that?
Yes, it is not deemed.
That is not possible today. We'll admit it and post it.
Then, Lordship,
Heard Mr. Jiju Sharma, learned counsel for the.
then 21, Lordship, on 21.
Also heard Mr. RKD Chaudhary, learned DSJ, appearing for the respondents. Full stop. The claim of the petitioner is that despite being the senior most eligible officer for being promoted to the post of assistant secretary under the T board, his case has not been considered by the authorities on totally untenable grounds by taking a plea that the vacant post of assistant secretary has been deemed to have been abolished. Full stop. According to Mr. Sharma, such a plea of the board is not borne out of the records. Mr. RKD Chaudhary, learned DSJ, on the other hand, submits that since there is no vacancy available at present, hence the case of the petitioner cannot be considered. After hearing the submissions of learned counsel for both the sides, and in view of the urgency expressed in the matter by the petitioner's counsel by stating that the petitioner is due for retirement on attaining the age of superannuation in the month of February 2025. This court is of the opinion that the matter would call for expeditious hearing and disposal. As such, admit the writ petition. Since the parties are already represented, no further notice is required to be issued in this case. List this writ petition for final hearing as a fixed item on 21/1/2025. On the next date fixed, the learned DSGI to produce the relevant records satisfying the court that the post in question has already been abolished by following the due procedure.
Obliged.
My lord, this is a competitive petition filed by the petitioner seeking winding up of the respondent company, my lord. Now, my lord, the matter will require some time. Actually, our stand is very clear, my lord. The date was not of the company. Two directors in their personal capacity has taken the loan. Therefore, company is no way involved. Therefore, the question of invoking the provisions of winding up doesn't arise. Secondly, my lord, the alleged claim is also barred by time. So many other aspects are involved. Now, my lord, we have filed an IA saying that this company petition is not maintaining. Essentially, it's not a debt owed by the company. Where is the question of invoking the winding up jurisdiction? That is essentially the main point, man.
So in any case, it will
require hearing, Mila.
Complete hearing.
Yes.
Even if your application is considered.
Yes, yes.
So everything.
So therefore, the whole thing has to be better is better, my lord. Lordship will go into the whole matter in one go.
My lord, that can be done. Actually, we have also filed one IA 2575 seeking permission to transfer this whole proceedings petition to the National Company Law Tribunal.
That is again
So,
not maintainable
actually,
for the simple reason, my lord.
because actually after amendment of the Companies Act, so while all winding up proceeding, everything shall be transferred to the NCLT. So whatever the limitation, whatever the payment and liability, whatever the method, that will be NCLT will dispose on this case in due course. So our petition has been filed. If that will be maintainable, if file is been transferred to the NCLT, then nothing remains here. So,
My lord, under the amendment of the Companies Act, my lord, all cases are not to be transferred to NCLT. I can just show, my lord.
Anyway, so
Anyway,
today
it may not be possible.
then can you suggest a date?
My lord, I was thinking of, my lord, if it is not inconvenient to lordships on 27th or 28th, my lord.
We'll have it on 8th of February.
Okay, my lord.
No, sorry.
8th of February is a holiday, my
No,
lord.
8th of February. We'll have
It's
it
a
on
Saturday.
11th of February.
Okay.
11th of February. Uh, You're right, Mr. Mr.
D. Sahu, D.
D.
Sahu.
Sahu, Learned Counsel, appearing for the company petitioner, as well as Mr. K.N. Chaudhary, Learned
Respondent,
Senior
ma'am.
Counsel, assisted by Mr. G. Khandelia, G. Khandelia. appearing-
Respondents 1, 2, and 3.
Respondents 1, 2, and 3. Uh, Appearing for the applicants in IS civil number 2267/2021. As along with Miss
Along with mail 2575.
Miss N. Rahman, Learned Counsel for the respondent number 4, have all submitted in tandem that there are several issues involved in the company petition as well as the respective interlocutory applications, including the question of maintainability of the company petition itself, which will require a detailed hearing, and therefore all the matters be posted for final hearing again on 11/2/2024. Since a joint request has been made by all the parties, fixed these cases for final hearing on 11/2/2025, this prayer stands allowed. Registry to list the matters accordingly.
Deep February, yes.
My lord, in this case, already they have filed affidavit in opposition. I have also filed reply, my lord. Now, in their affidavit in opposition, they have not admitted anything to comply the order, my lord. Only stated that on 31/10/2020, they have sent a proposal to the deputy secretary.
What is the order?
My lord, order.
Where is the order of the court?
Order, my lord, the last, the main order, my lord. That was, my lord, passed by the, on writ petition number 5290 of 2020, my lord, page 64, annexure 12. Next page 65. my lord.
1 minute. So, see, the problem is no order can be passed in your case. Because this matter, finance department should have been a party. Without the finance department, money has to be released by finance department, is it not?
My lord, they have already sent, my lord, the proposal, my lord. They have already sent, my lord.
That's all. The matter is over.
No, my lord.
These are mistakes which has been repeatedly committed by the learned You were not there in the earlier round.
Yes.
Nothing can be done. I'm adjourning it to try your luck somewhere. I will dismiss this contempt case. Monetary matters without the finance department, nothing can be done. And that order, the finance was not a party. The learned judge has passed an order. See, contempt is about willful violation.
Yes, madam.
The department doesn't have the money. The fund has to come from finance. If the finance doesn't give the money, where will they pay from?
My lord,
You understood, na?
yes, I have
So
understood.
nothing
my-
can be done.
my
What do you
only-
want? Closure of this with liberty
No,
to
no,
file
no.
fresh writ petition? Adjourn on the prayer of Miss. You can't help it. These are very, very straightforward. I just don't understand why repeatedly these mistakes are being made. Any matter where financial involvement is there, finance has to be a party. Because if finance was a party, we could have issued a notice to the finance secretary commissioner. That also cannot be done. They will come and say that we were not heard. In fact, nobody's stand is reflected in the order. See, contempt cannot be used like this. Contempt is a very sacred jurisdiction. When there is really violation, somebody's right is tinkered with, then the courts will come heavily, but not in this casual manner. How many weeks' time you want? I'm sorry, nothing can be done. I have taken this stand consistently. Perhaps your client may get relief in next 2-3 years if you still withdraw this and file a writ petition. Otherwise, no chance. You'll get nothing.
After 2 weeks, my lord.
You examine it.
Yes, yes.
This is completely faulty proceeding. No contempt
After
will
2
lie.
weeks, my lord.
In the prayer of Ms. N.S. Thakuria, learned counsel for the petitioner, this matter stands adjourned for 2 weeks so as to enable her to obtain updated instructions
Yes.
from her client. Mr. S. Rava, learned counsel, is present on behalf of respondent numbers.
My lord, one,
Five.
two,
Five.
one.
See,
One-
you have understood what I'm saying.
Yes,
You
yes.
will never get the fruit. Even if some order is passed here or there, the department, it can't be done. There is a procedure which is followed by the government. There has to be, finance department has to sanction budget. They have to be heard. If they agree, disagree, doesn't matter. But the court will have to hear them. They will have to be made party. Otherwise, the government will crumble tomorrow. If everywhere financial orders are passed without the finance department knowing, responsible judges will never pass such orders. I'm sorry to say this.
Obliged, ma'am.
You may not like to hear this, but this is the reality. That's the reason why so many contempt cases are coming.
Obliged.
Lordship, this review petition is already covered by Lordship's earlier order.
Will you give that order?
Yes, Lordship.
Mr. C. Goswami and the
C.
same.
Sharma, Lord.
C. Sharma. Same order. It will be the same, just case number will be different. Disposed of.
Yes, Lordship.
Forty-three is over.
May I please, Lordship?
Yes.
My lord, in this IA, I am praying for keeping the post vacant in which I was declared to be qualified but not given appointment because it has been erroneously held by the respondents that I am not a person with benchmark disability. I claim myself to be a person with benchmark disability. A reassessment was conducted during the recruitment process and it says that my percentage of disability is 23%, which I am assailing in the connected with petition. And I claim that my percentage of disability is 57.1%. So what has happened pursuant to that, a fresh advertisement has been held. Examinations also held on 29th of September 2024. And if the results are declared, fresh candidates will be declared qualified. Then they might be given appointment later on after the reassessment. So new candidates will come in.
Just a minute.
My lord.
You participated in the process which was pursuant to which advertisement?
Advertisement dated 25/3/2022.
25/3/2022. Okay, you appeared as a candidate with disability.
With the benchmark disability, yes.
Benchmark disability.
I claim.
So benchmark disability is 40%.
40%.
According to you, you had 57%.
57.1%.
1%. But later on, they subjected you to another
reassessment, which was done by the medical board of GMCH, and the medical board reassessment says that I am 23% disabled.
23%
Disabled.
So
In the
therefore,
first, there were two reassessment actually. My lord.
have your patience.
My lord.
You will be shocked in next 2 minutes.
My lord.
Don't worry.
Yes, my lord.
So they said you are 23% disabled.
My lord.
Therefore, you are not entitled to appointment as a person with
Benchmark
disability,
disability.
benchmark disability. What happened to those posts which were advertised by 25/3/2022?
Those are lying vacant.
Those are lying vacant.
Lying vacant.
No recruitment has happened.
In that post, no.
Okay. So you want one post to remain vacant.
Vacant.
Of which recruitment? The earlier one or the new one? Now a fresh advertisement has
Fresh
been.
advertisement has been.
When that has been issued?
The fresh advertisement was held 30/10/2023.
So what happened? The earlier vacancies, the candidates were not available.
No.
Lordship, here I am appearing for the recruitment, state level recruitment commission. Lordship, we selected the candidate as per the vacancy proposal given by the various department. And thereafter, they were subject to, as Lordship has seen, to another review medical board. And thereafter, the vacancy, what the department has done, Lordship, that we are not within our knowledge, Lordship. And subsequently, the new advertisement has been issued, written examination held, evaluation is under process. Maybe, Lordship, those vacancy may have been included by the department in the subsequent proposal.
So who will be able to answer that?
Lordship, that he applied for 2 categories of post in 2 departments.
Which are the 2 departments?
Lordship, one is the cooperation department, and the other is the Panchayat and Rural Development Department.
Okay. They are not present here today, is it?
Lordship, the affidavit has been filed by the 8109.
No, we'll see. Forget the affidavit right now. Have you filled up all those vacancies for persons with benchmark disability category? You had some vacancies in your department, cooperation?
Our department, there are some vacancies, right now, I thought, honorable this vacancy is reserved for.
Achha, now see, the point is, your right, if any,
Yes,
is pertaining to only the selection conducted by notice dated 25/3/2022.
My
There is no question of passing any interim order based on notice dated 30/10/2024. Question doesn't arise.
My lord.
Because that's a completely wrong legal fiction you are relying upon.
My lord.
You can only say that appoint me against the vacancy which were advertised on 25/3/2022.
My lord.
That order, if you succeed, then you get relief. Otherwise, you don't get relief.
Yes, my lord.
So you have to ask for that relief. Now you are asking for something else. What your interlocutory application says is that you want one post to be kept vacant of the next advertisement. That cannot be done.
My lord, if I may be allowed, my lord, the procedure is that during the recruitment process, this post under the cooperation department is reserved for person with benchmark disability. I was held to be qualified. Since I was held to be qualified, so I had to undergo through the medical reassessment test. If I succeed, I get the appointment. If I don't succeed, I don't get the appointment and the post is vacant. So the post was lying vacant. At that stage, I preferred a repetition before this honorable court.
You were interested in the post in the cooperation department.
There are two posts. Yeah, I'm for the cooperation department and for the Panchayat and Rural Development. I applied for 2 posts. I was held qualified for 2 posts. And I can select any one post at the appointment stage.
Who is for the Panchayat and Rural Development? Have you served a copy on him?
Panchayat Rural Development.
Who is the council for Panchayat and Rural Development? But have you given him copy of the IA?
Yes, we have served copies to all the departments, my lord.
All right, then we'll have it on Wednesday by showing the name of Mr. S. Datta. You also tell us, Ms. Bora, what has happened? How many vacancies? Did you fill up all vacancies? How many are still there?
My lord, the vacancy matrix is annexed here.
No, but we want to hear from her. She says she
My lord,
wants.
my lord.
When? Next Wednesday, Thursday, whichever?
Lordship, I have got no.
Thursday?
for me.
Thursday, my lord.
All right. Heard Mr. Your Mr.
A Khan.
A. Khan, learned
Madam.
counsel for the applicant. Also heard Mr. B. Chaudhary, learned standing counsel appearing for the state level
Recruitment Commission.
Recruitment Commission. Ms. M. D. Bora, learned counsel, is present for the Transport Department, Corporation Department, Assam. In the writ petition, Panchayat is not a party. IA. No, IA is okay, but writ petition is Panchayat a party.
No, my lord, Panchayat rural is not a party. That means, my lord, I won't be able to claim on that post in that case. But the corporation department, I can raise a claim. I cannot.
You figure out what you want to do. Since the
Maybe allowed to implement them as a party now.
you can, then you have to file an IA.
Yes, yes, my lord.
You want to file an IA.
I'll file an
The applicant is claiming appointment against post reserved for persons with benchmark disability in the Corporation Department as well as the Panchayat and Rural Development Department of the state of Assam. And on that behalf, an interim relief has also been sought in the present IA. However, Panchayat and Rural Development Department has not been implemented as a party in this proceeding. In view of the above, applicant stroke writ petitioner is granted leave to implement the Panchayat and Rural Development Department as a party respondent in this proceeding so as to press for the interim relief. Let this matter be listed again as soon as the IA for implement is brought on record. You will file an IA.
I'll file the next week. Maybe a date, maybe fixed.
As soon as it is filed.
My lord, my lord. Obligement.
May I please the Lord. Herein the candidature of the petitioner was rejected on the ground of below height, Your Lordship. But in the order, Your Lordship, in the order para 2, Your Lordship, that has not been reflected, Your Lordship.
Sorry, where?
In para 2 of the order, page 15, Your Lordship. Actually, they have been rejected on the ground of below height, Your Lordship. But herein in para 2,
So what height or chest or we have not mentioned why.
chest and height, Your Lordship, but
No, we'll close it. There is nothing. Why they have been rejected, we have not disclosed. You prefer an appeal, take that ground in the appeal.
but they have said, Your Lordship, these are the test of hamartosis of both feet, knee. These all are the petitioner, they have not been participated, Your Lord. They have not participated, Your Lord.
Heard Mr. A.M. Khan, learned counsel for the applicant. Also heard Ms. S. Borua, learned CGC appearing for the respondents. His IA has been filed with a prayer to clarify, to modify the order dated 11/11/2024 passed by this court in WPC number 5769 of 2024 by contending that the applicant's writ petitioners were rejected on the ground of not meeting the requirement of height as per the prescribed norms. However, full stop, however, according to Mr. Khan, since the said fact is not reflected in the order dated 11/11/2024, there is a strong possibility that the appeal preferred by the applicants pursuant to the leave granted by this court by order dated 11/11/2024 will not be considered in the correct perspective. Hence this application. Ms. Borua, learned CGC submits that the aforesaid aspect of the matter can be clarified by the court. In view of the above, and considering the facts and circumstances of the case, it is hereby clarified that the appeal preferred by the applicant pursuant to the order dated 11/11/24 can include all grounds grounds that may pertain to any area of challenge, including rejection of the candidature of the applicants on the ground of not meeting the height requirement. With the above observation, I extend this paper.
And this order may be treated as a part of order dated 11/11/2024.
No, it's clarified. Clarified means. Last item.
May I please your lordship, there is a IA for modification and alteration of order dated 25/9/2024. The order is at page 11, lordship. Lordship, may I read?
That is page 11.
Yes,
What
lordship.
is there to modify here?
Lordship, that the subsistence allowance, gratuity and leave encashment dues payable to the petitioner has already been released. Lordship, the gratuity has not been released, lordship.
Whatever amount about 16 lakhs gratuity, they want to adjust it for the time being against the alleged loss of the bank due to the NPA, amount NPA. The amount NPA has gone to NPA. So that let it remain. That will decide in the final hearing, my lord. Now, this other things your lordship has ordered, leave encashment, then my lord, subsidy allowance, etc. Amount.
Oh, there she is saying just a clarification, the gratuity has not
Yes,
been.
lordship, that is.
Yes, that's all.
No
Yes,
objection.
yes.
Yeah, that is true. That is no objection.
All right, heard Miss
Yes, Yasmin, lordship.
S. Yasmin, learned counsel for the applicant. Also heard Mr. R.P. Sharma, learned senior counsel, assisted by Mr. D. Dole, learned counsel appearing for the OP stroke rate petitioner. This IA has been filed with a prayer to rectify an error in the order dated 25/9/2024, passed by this court in WPC number 6917 of 2023, whereby the learned counsel for the bank has been, whereby it was recorded that the subsistence allowance, gratuity and leave encroachment dues payable to the writ petitioner had also been released by the bank by quoting the submission of the learned counsel for the for the applicant bank. So Ms. Yasmin submits that the gratuity amount of the
Yes, has not been.
opposite party writ petitioner is yet to be released, and therefore the order dated 25/9/2024 requires to be suitably modified, stroke clarified. Mr. R.P. Sharma, learned senior counsel, has also agreed to the said proposition. In view of the above, this IA is being disposed of by clarifying that the observations made in order dated 25/9/2024 to the effect that gratuity amount of the writ petitioner had also been released shall stand deleted. Stop. This order shall be read as a part of the order dated 25/9/2024.
Only that, my lord, their other amounts, amount of 4 lakhs or something, they have deposited in the ODI account. So I am not in a position to rise. Let them deposit in my savings bank account. So
That too, we can't pass in their
Yes, Lordship, this is
application.
an IA.
The remaining part of the order will remain as it is. This order shall be treated as a part of the order dated 25/9/2024. Highest and we file an IA, we'll pass it.
Or my lord, can it be taken for final disposal? Because the man is out of service, my young man.
All right. In the writ petition, you write so and so for the petitioner, so and so for the.
Pleading is ready.
Right. Mr. Sharma submits that the writ petition is ready as regards pleadings and service. And since the petitioner is out of service, out of employment, the petition be taken up for expeditious disposal. On the request of Mr. Sharma, learned senior counsel for the registry to list this case again on 13th of February 2025 as a fixed item. 13th. 11th February. 11th February.
Yes, sir.
11th of February.
Deeply obliged.
Item 31.
Yes, what is this?
Lordship, the petitioner is working as a railway protection special force on the Indian
There's a
Railway.
VC request here. Why? Who wants VC? Somebody has made a VC request here. All right. You are appearing for the petitioner.
Yes, sir.
Yes, what is your case?
PJ Das.
What is your case? Yes.
Sir, the petitioner is working as a railway protection special force on the Indian Railway,
So
sir.
VC is not required now, is it?
No,
Not required.
no, sir.
Okay.
So he joined the force in the year 2008. So due to illness of his father as well as his mother, he was not regular. Sir, he was in unauthorized leave for 69 days. So because of that, sir, he was terminated.
Case of termination from service. All right. Mr. Your name, please?
Sir, PJ Das.
PJ Das, counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner was serving as what? GM escort, serving
Yes, constable, my lord.
as a constable in the Railway Protection Service Force, bracket RPSF, when his service was terminated by order dated
Sir, 34 of 2024.
30/4/2024. Assailing the order of termination from service dated 34/2024, the instant writ petition has been filed. Mr. H. Gupta, Lanet CGC, appearing for the respondents, prays for some time to obtain instruction and file affidavit. Issue notice returnable in 4 weeks. Since Mr. Gupta has appeared and accepted notice for all the respondents, no formal notice, extra copies, etc., etc. Who wanted to appear through VC?
Sir, actually, no idea.
You are not aware.
No.
Then why requests are made for VC when the council is not interested? Huh?
Email has.
You inform whoever the person is that when the VC was allowed, he was not present. Okay. Yes.